The problem of sorts was that 2 of the 5 justices said their opinions were qualified. It was like, well, it's unconstitutional as currently administered. Others were like, it's just unconstitutional, we're done. But everybody thought it was done. Even the 2 that said as currently administered never expected that states would then say,
Buonasera a tutti, benvenuti nella serie delle interviste di Extrema Lazio. Quest'oggi abbiamo il piacere di ospitare la professoressa Corinna Barrett Lain dell'Università di Richmond. Good evening, Professor. It's a pleasure to have you. Professor Lain is a constitutional law scholar who writes about the influence of extra-legal norms on Supreme Court decision-making, with a particular focus on the field of capital punishment. She is currently visiting professor at the University of Bologna Alma Mater Studiorum. Her book, Secrets of the Killing State, The Untold Story of Lethal Injection, is forthcoming in 2024 for New York University Press. So, we are very happy because we have a great chance to talk with a well-known American death penalty expert. The ultimate sanction, an issue that fortunately can look distant and even outdated to our European and Italian eyes, in light of well-known international constitutional human rights law developments, but nonetheless surely maintains its urgency in the general reflection on the morality of states' power to punish. So thank you very much, Professor, again. We are very happy and grateful to have you here and to have the chance to talk with you about such an important topic as the death penalty. Let's start our conversation from the current state of the American death penalty and the role that is played by the Supreme Court today, also taking into consideration the hard conservative turn that was taken recently by the court, also with its focus on originalist methodology of constitutional interpretation. Thank you.
Yeah, sure. It's a pleasure to be here. Thank you so much for the invitation. So today, the American death penalty is a contradiction of terms. On the one hand, the Supreme Court, as you rightly recognized, has taken a very sharp right turn, very supportive of the death penalty. Certainly in many areas, anything goes. Looking at the Supreme Court's jurisprudence more generally, it's green light all the way to executions across a number of different areas. So on the one hand, the Supreme Court is saying, we like death. On the other hand, despite the Supreme Court's support for the death penalty and green lighting it as much as it possibly can, the American death penalty is dying. Slowly, but surely it is dying. A death of 1,000 cuts, I would argue. But in the last 2 decades, death sentencing is down 88%. And that's, sharp, very, very sharp. And death sentencing is very important because today's death sentences are tomorrow's executions.
And both are sharply decreasing, right?
Yeah, and executions are down 77%. Over the last 2 decades. So this is, that's the death penalty on the ground. Death sentences I always think of as the spigot, that they keeps the machinery of death running. And it's down to a trickle. Last year, maybe 18 or 20 death sentences in the whole country. I mean, just a very small amount. States are getting rid of the death penalty on their own. 8 states have abolished the death penalty on their own. So a very striking contradiction.
Between this, let's say, pro-death penalty stance by the Supreme Court, the Supreme Court justices will say that it's pro-democracy, though not pro-death penalty, but they are very, very open to uphold the death sentences, right? And on the other hand, as policies like legislation in the states, the support is falling very, very quickly, support for the death penalty, right?
That's correct. I'm really glad that you mentioned this piece of it, because the Supreme Court, in its conservatism, says, don't come to us. Take it to the legislatures.
Take it to the people. Right?
Take it to the people. We don't want to get involved in this. Take it to the people. The problem with that is that majoritarian rule and taking it to the people doesn't work out very well for you when you are an accused capital murderer, right? Capital murderers, they have no political power. They can't vote. They have no political action committee. And legislatures are not going to say, you know what, let's give more.
So we will say that the judicial counter-majoritarian protection is absolutely essential.
Absolutely. This is exactly.
You cannot have a judicial and hands-off approach in this field.
Absolutely. You know, one would think that the Supreme Court would say, of all the places for us to step in, it's here. And if we think back to constitutional formalism and structure, right? We have in America, we have the legislative branch, it's elected. We have the executive, it's elected. And we have the Supreme Court, not elected. Why is it not elected? It's not elected because we recognize that democracy sometimes is 3 wolves and a lamb deciding what's for dinner, right? It doesn't work out so well, right? So this is the place where you wouldn't see that. And yet, that's what the court says. So in some way, it's ridiculous for the court to say that. In the other way, you look and say, and states are getting rid of the death penalty on their own. So are they protecting? Is that what this is about? Have they recognized the depravity of human beings killing each other on purpose and the state killing someone on purpose with other people filing into a room to watch? No, it's actually not about that at all. It's that the death penalty has become too expensive, and that is something that legislatures do respond to. So they're not really responding to the...
Indeed, we have seen in recent years, like in the last 5 years, many legislative repeals of the death penalties, of the death penalty by, for example, the state of Virginia, repealed the death penalty, and also in general, like rates and of executions and death sentences are falling, as we were saying before.
Yes.
And putting it in historical perspective, the Supreme Court, is correct to say the Supreme Court had played a major role in policing, in the judicial review of capital punishment, especially in the so-called modern era of the death penalty, right? Since the 60s, maybe you could say something more about this abolitionist movement that was developing in the United States in the 60s, and then the Supreme Court ruled on the subject in a very in a landmark case that was called Furman versus Georgia, right, in 1972. And if you'd like to tell us what the meaning, the historical meaning of this ruling, and then of that was maybe the end. It looked like the end of capital punishment in America, but then it was reinstated in 1976 by following the decision of Gregg versus Georgia. And if you would like to say more about these developments and what's their meaning for American capital punishment.
Yeah, sure. You know, I first have to say your questions are fabulous. They really are, you know. Many Americans don't know that the United States did not have a death penalty from 1972 to 1976. You know, we had abolished the death penalty. Most Americans would say, what? We didn't have the death penalty? What is this? I thought we always had a death penalty. So, you know, just the fact that you know of this and know of this history, and it's a very important history. So, very briefly.
Yeah, very briefly, of course.
There was a time when the United States was moving in lockstep with the rest of the world, including European abolitionism, in the 1960s. In the 1960s, there was a worldwide abolition movement. The number of nations that abolished the death penalty doubled in the 1960s. And the United States was in lockstep with that. Executions in the 1950s were in the 1950s, they averaged 50-something. By the time we get to 1963, it's like 25, and the numbers fall from there. They go 25 to 15 to 8 to 5, 2, 1, you know, the numbers just drop. And from 1968 until 1977, there are no executions at all. So by the time you get to 1972, and 1972 becomes a very important date for us because that is the year that the Supreme Court abolished the death penalty. But, you know, just putting ourselves back in that time period, you know, the fact that in 1972, the United States had not had an execution in 5 years.
Pretty long.
And by all accounts, we were surviving just fine. You know, and death sentences at the time, the juries were only giving death 10 to 20% of the time that prosecutors were asking for it. Imagine being a prosecutor and losing 80% of the time. Right, it was just crazy. And even people who had already been sentenced to death. I'm a legal historian, and so I got into the reports at the time, the papers, the newspapers, the magazines. What were they talking about? And the thing that they were talking about is that governors were not interested in signing the death warrants. These people were just languishing on death row. You know, and they were talking about America has lost its taste for death. So Newsweek magazine talked about the dying death penalty, right? U.S. News and World Report magazine was also talking about the end of the death penalty. This is what it looked like at that particular time. And I think that much of that was also driven by the civil rights movement, the war on poverty. People were recognizing, really coming to terms with our own ugly history of racial discrimination and economic discrimination and unfairness. And many people looked at the death penalty at that time and said, this is the ultimate expression of race discrimination and of unfairness, income inequality. And you know, if we think it's not okay to segregate schools and have racial inequality in our schools, well, we certainly don't think it's okay when your life is at stake. So there were these larger movements, social movements, that were driving abolition sentiment. But, you know, even the public opinion polls at the time was showing less than 50% support for the death penalty. It was just kind of crazy. And even if you think about it, in 1968, Richard Nixon won the White House, won the presidency on a law and order campaign. And yet
it was a time of social unrest
Oh, yeah,
violence.
exactly. So the country turned very sharply conservative. Richard Nixon did not campaign on the death penalty. Can you imagine?
It was not a national issue at the
No,
time.
he didn't mention it. And the Republican Party platform, silent. So it's just an indication, as you say, there was this abolition movement, and the Supreme Court took up the constitutionality of the death penalty in 1972.
Under the Eighth Amendment, right?
Under the Eighth Amendment.
Cruel, unusual punishment.
That's exactly
prohibition,
right. Yep. So the Supreme Court took up the constitutionality of the death penalty under the Eighth Amendment, Cruel and Unusual Punishments Clause, and the court struck down the death penalty. And at the time, in some ways, given the abolition movement, it's like, okay, the court, these justices, they're people too. They read the papers, right? They're part of the national conversation, and to the extent that the nation was turning away from the death penalty, particularly elites, intellectual elites.
That is, I would say, the most important part, how it relates with the Supreme Court justices, according to some studies, right?
Yeah,
the
that's
elites,
exactly right. Elite opinion,
they're responsive to elites more.
Very.
Many studies say, right?
Very. And so in some ways it wasn't surprising to see what the court did. In other ways, it was quite surprising. Furman versus Georgia, decided in 1972, was at the time the longest Supreme Court decision in United States history. It was over 230 pages. Every justice wrote a separate opinion. And it was a 5-4 decision, because we have 9 justices, so it was 5-4, very close decision. And each of the 9 justices wrote their own opinion. And none of the 5 justices in the majority joined any of the other majority opinions. So each opinion had only one vote, and you had to read them all to even figure out what was the holding of this case. We knew it was accompanied, by the way, by 1 paragraph per curiam, 3 sentences opinion that said, we hold the death penalty as currently administered to be unconstitutional. See below. And that was
see
it.
The 9 different
see all of this.
With all different rationales.
Exactly. And the problem of sorts was that 2 of the 5 justices said their opinions were qualified. It was like, well, it's unconstitutional as currently administered. Others were like, it's just unconstitutional, we're done. But everybody thought it was done. Even the 2 that said as currently administered never expected that states would then say, you said as currently.
Which are the main, the basic reasons for unconstitutionality of the death penalty in Furman versus Georgia, examining the whole body of opinions, of different opinions?
Okay.
Why the death penalty, the justices thought violated the Constitution, the Eighth Amendment? Yeah.
So the thing that they all had in common,
the
common rationale, was that the death penalty as then practiced was arbitrary and capricious. It was arbitrary and capricious because there were no standards to guide the jury's decision-making. Once the jury found the person guilty, really, truly, I've looked at the jury instructions, it was basically, so what do you think? Do you want them to live or do you want them to die?
And the problem of arbitrariness.
Yeah, and anything goes. Anything they wanted. And the court looked at that and said, that's lawless in its most literal sense. There's no law to guide you. So the other justices had other.
We could say that it's a procedural aspect, right? Rather than substantive, right?
Yes, for some of the justices. I mean, Justice Marshall and Justice Brennan, they had multiple reasons Justice Brennan had 4. I think Justice Marshall had like 6 or something like that, but multiple reasons. And both of them thought it's also immoral. It's
Against
also
human dignity,
exactly.
Right?
So there were, they were, no, we're done. We're all done. And also, it's arbitrary and capricious. That was the common thread. That was Justice Marshall and Justice Brennan. Justice Douglas, his opinion focused on it being racially discriminatory. Justice Stewart was a core arbitrary and capricious. He had the famous line that getting the death penalty was like being struck by lightning. And then the last one, Justice White, said it's arbitrary and capricious, and because it's arbitrary and capricious, it cannot serve a legitimate penological function.
Okay, and after this very important decision, Furman, the states enacted many statutes, right?
That's exactly right. So
showing popular support in a way to capture.
Well, yes, that's true. What happened is just a fascinating turn in American constitutional history, because you had these 2 justices, Stewart and White, that were, again, in the majority, but it was as administered. One of the justices in the dissent was Chief Justice Burger. And Chief Justice Burger was a death penalty supporter. And he said, I'm for it. And also, notice that those 2 justices didn't say forever. They said, as currently administered. And just
in the dissent, right?
In the dissent. And Chief Justice Burger pushed.
So in a way,
he poked
to
them.
Legislators, right?
Oh, yeah. In fact, it was explicit. Not even in a
advice
way.
maker.
He said, state legislatures have a duty to reconsider their statutes and to see if people, he said, this is a good opportunity. I disagree with the decision, but it's a good opportunity. You have a duty to take it back to your people and see if they still want them. So he pushed.
And this is what actually happened after.
Well, it is. And then what happened, another piece of this puzzle that's important to understand, is that the South, so the South was still very angry over Brown versus Board. Yes, very.
Court-mandated desegregation.
Exactly. So Brown versus Board of Education.
But counter-majoritarian ordered by the Supreme Court.
That's exactly right. And in the South, which of course was the bastion of slavery, there were really 2 pillars of racial subjugation. One was about education. Right? Let's make sure that Black and brown children do not have good education, keep them powerless. The other was racial terrorization, and that was the death penalty. So the Supreme Court had knocked down one pillar and had just knocked down the other one. And the South was very, very angry. And so they were like,
okay, we're
going to pass these statutes immediately. But they started a conversation and it picked up steam. And so one of the things I think is just so very interesting is that the state of New Mexico,
it's not strictly speaking a southern state,
no,
it's a western state.
Exactly. It was a western state. It wasn't part of the Confederacy or anything like that. But there was this discourse of, even if the death penalty is bad, you, Supreme Court, shouldn't have taken it from us. It should have been a democratic decision, should have been for us to decide. And this became such a discourse that even New Mexico was like, yeah, you took it from us. New Mexico had gotten rid of it itself. It was one of the 8 states that had abolished it on its own in 1969. So they didn't even have it, and were complaining.
It was not the Supreme Court in 1972,
no,
but it was a democratic choice.
Right, but I mean, they were like, you took something from us, and it was like, you didn't even have it. What are you talking about? So, but it started, it turned, and there's been some debate in the United States among historians. I'm part of that. Some people have said, well, it was unfortunate because of crime rates. It was this, it was that.
It was too early, maybe, because
it was too early, it was too late.
You
Maybe it would have been better in 1966.
Similar talk has been in place for Roe, for example, right? In
True.
abortion context,
True.
They say they should have not ruled on the constitutional abortion because it was unfolding at legislative level and the Supreme Court. But yes, there are some similarities, true. Right?
There are. I've written about Roe too. So, so the thing is, if you look at the original sources, if you look at the contemporary discourse, what were people saying? What they were saying was, isn't that weird? The Supreme Court decided a case that was moving with public opinion, and when the court decided the case, it changed public opinion. That it itself changed the direction. It wasn't so much about crime, it wasn't about this or that, it was about the Supreme Court's intervention. So this is very interesting to think about as a Supreme Court scholar. But for our purposes, the purposes of our talk, you are exactly right. What happened is 35 states passed new death penalty statutes, and the Supreme Court took up the constitutionality of those in 1976 in Gregg versus Georgia, and the Supreme Court upheld most of those. So the states at the time passed two kinds of statutes. The states said, oh, it's arbitrary and capricious, we are hearing you, we understand that. Some states said, we will pass guided discretion statutes that guide discretion so it won't be arbitrary and capricious. That's one way to deal with randomness. Other states, sadly, Virginia was one of them. That's my home state. But other states said, you don't like discretion, you don't like arbitrariness. We've got a way to fix that. Mandatory death penalty. If you're convicted of this murder, automatic death. Then you don't have to worry about randomness because everybody gets it. And so when the Supreme Court in 1976 decided Gregg was 5 cases. It was 3 consolidated cases. It was 3 guided discretion statutes, 2 mandatory statutes. The court upheld the guided discretion, struck down mandatory. And that leads us to the modern...
On the ground that it was offensive of human dignity, basically, right?
No, not so much, no. So we had, so it's so interesting. You had the 3 justices in the middle, and then you had 4 justices on one side that said, mandatory are okay, and guided discretion are okay. And you had justices on the other side that said mandatory are not okay and guided discretion are not okay. And then the 3 combined with the others for this decision. But, some of them, this was Brennan and Marshall, they said that is ridiculous,
so
you're correct.
Justices who opposed that penalty
then they said that's even worse, it's inhumane. However, the reason that got the most votes against the mandatory death penalties, very interesting. What the justices said was, it's still going to be arbitrary and capricious. We're just moving it to another level, because what will happen is, if a jury knows that it's a mandatory death penalty and the jury doesn't want the person to get death, the jury's just going to acquit. And so what the justices said was, it's going to be just as arbitrary, it's just going to be buried under something else.
Okay, dear Professor Lain, you illustrated Furman and Gregg cases, and we could say that after the Gregg decision in 1976, the United States death penalty steadily increased, the execution and death sentencing rates spiked, especially in the 80s and in the 90s. Yes. So the big question is, how did we get where we are today? As you said before, today the death sentences and execution rates are falling down, are very low compared to the 80s and the 90s especially. So what do you think about this trajectory from Gregg to today?
Well, first is to say that it really did spike. I mean, we were talking about 270 death sentences a year. Death penalty support spikes in the early 90s. It's 79%. Can you imagine 8 out of 10 Americans agreeing about anything, and yet they agreed about death? So it was really strong. So I think a couple things are happening. The first, though, is that lawyering was really bad. And that was part of the reason why we had so many death sentences. And yet DNA hits in the late 1990s. And by 2000, we have an actual innocence explosion, right? Journalism students at Northwestern showed that a person was completely innocent and saved him. He was hours away from an execution. And the randomness of that it wasn't lawyers, it was a bunch of journalism students. And then they started looking closer. And so that was a crisis of confidence, I think, in the death penalty, when people realized that we could actually be getting this wrong. That grabs people from both sides of the aisle.
Final, so there's no
right.
remedy, so people
there's no do-over.
Yeah, people realize that you cannot.
Yeah, and so that made people look at the lawyering. And they realized, yes, and they realized it was really, really bad. Really bad. So finally, the Supreme Court decides a case. It was a case out of Virginia, actually. It's the first time that the Supreme Court overruled overturned a death sentence based on bad lawyering. And it was a case out of Virginia, but it said something to all of the death penalty states. If you want your death penalty, you've got to give minimally competent lawyering. So states start increasing the lawyering. And I think this is a story where we are today has a whole lot to do with lawyering.
We super trained as specialized lawyers.
We did. And the thing is, the Supreme Court, which is giving the green light for death, go, 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 the Supreme Court inadvertently helped create it, because the Supreme Court, every time it decided a case, it becomes more and more complicated. The law of the death penalty is a very complicated law.
It's also habeas law, right?
It's habeas, it's trial, it's mitigation, it's complicated from A to Z. And so once you said, okay, we've got this complicated law and you need good lawyers, or at least minimally competent lawyers, then they started looking at this saying, oh, you need to specialize in this. If you're going to practice it, you need to.
May I ask you a question, Professor? Like, what is the most important thing a capital lawyer has to do in front of a jury if he or she wants to save life of her client or his client?
Humanize.
Humanize. Okay.
Humanize them. That's it. Humanize them and tell their story. Because these people, and I've studied case after case after case after case of them, they don't come from the same places that you and I did. They have been terrorized their whole life, and there is an anger and violence inside of them and a break of empathy. And oftentimes what the social psychologists say is that they have been brutalized so much and so often that their mind, as a survival technique, takes them somewhere else, so that they're not present and feeling what's happening to them, just to survive it. And then what happens is they can go somewhere else and they've lost their empathy. And now you've got someone raging with anger that cannot be empathetic. So in any event, it's very, very important to humanize the client. And what these lawyers are doing is they're telling their story, and then they're saying to the jury, if these things happen to you...
These elements you're referring to are the mitigating factors,
thank
right?
you. Yes, thank you.
Right? Like when these lawyers are arguing in front of a jury, they are pointing to all these, for example, violence that the defendant, the capital defendant, has suffered in their youth or childhood, or also drug abuse could be, or anything actually, according to Supreme Court case law, right?
Anything. But we call that the case in mitigation.
Case in mitigation.
And nowadays, capital litigation, at least at the trial level, it's all about the case in mitigation.
So they have to be, this is what I imagine, I've never seen one directly, but the capital lawyers law firm, they're very, like the ones at least, I suppose, are effective. To be effective, they need a lot of research and psychology, to delve into all of the possible aspects of the personality and the history of life of the defendant, right?
That's right. They all have on their team, they have someone called a mitigation specialist, and they are investigators of people. And they are talking to the relatives, and they find out all of these things about these people.
Really, really interesting.
And can I just tell you, because it's such a nice example of how this worked. In Virginia, because that case came down, Virginia said, okay, we better create some public defender offices that have capital defenders. So they did a study. And the Crime Commission in Virginia said, you need at least 6 regional offices. Create regions. You need at least 6 because there's many, many capital indictments in Virginia because Virginia loved its death penalty. The General Assembly said, you say we need a minimum of 6, we'll give you 4. All right, so the Virginia General Assembly was not trying to actually give them what they needed. They gave them less, right? And yet, these capital defenders, because they specialized and got very good in it, they had over 250 capital cases. Of the 250, a little more, that they handled, only 10 went to trial with death on the table. Some of them they pled out, some of them they did other things, but only 10 of 250 went to trial with death on the table. Of those 10, 4 ended up in a death sentence, 6 did not. Of those 4, 1 was overturned on appeal because they limited the amount of mitigation evidence.
A terrific job.
Well, it's so much. 4 turns to 3, 3 turned to 2 because there was prosecutorial misconduct. In the end, Virginia abolished the death penalty because we did not have a new death sentence in 10 years. The death penalty was already dead. So then it's like, well, now I'm just paying the cost. Might as well get rid of it.
This is part of a general trend.
Yes, and this is it. Yeah.
And at the moment, how many states have that penalty? Have the death penalty on the books? 30?
Well, so 26 states either do not have a death penalty or have a death penalty on the books, but governors of 3 states have declared an official moratorium. So, when you think about who can execute, it's only 24 states now. That's slightly less than half. For the first time in American history.
We are talking about the importance of lawyering, and actually good lawyering for saving defendant lives. And so you like to add something to this aspect, please?
Yeah, so what we've been talking about is the importance of good lawyering at trial. and how you can save people from getting death sentences, and that kills the death penalty because there's no death sentences feeding in. But there's one other aspect. The other half of this is what happens after trial. After trial. And that comes to really good lawyering too. Because it's so complicated, the lawyers have thought of all of these arguments to make. It's very technical, but they have many arguments. And then there's really important things that they are finding and litigating. So right now, 2/3 of all death sentences in the United States are overturned on appeal at some point. 2/3. It's a lot. And the number one and number two reasons are ineffective assistance of trial counsel,
So Sixth Amendment violation.
Sixth Amendment violation, and prosecutorial misconduct. So these are important claims. They're winning on these claims, overturning death sentences. But the other thing, briefly, is that just the fact of litigation, because as you recognize, there's habeas litigation, the appeals last a long time.
It's a nightmare, habeas.
It is very complicated. But it drags out the time between death
and this
and
is a
execution.
Very important issue, right? Also
very
for
important.
The penological purpose.
Oh, yes, it is. Yeah.
This was a very good dissent by Justice Breyer.
Yes.
Highlighted all these
Yes.
these factors.
Yeah, no, you're right. I mean, it makes it more expensive. Again, you're not getting the sentences or you're not getting the executions. And when you're not getting the executions, you don't have the retribution. You don't have the deterrent effect. You're not getting the purposes of what it's about. So and so all of that, the lawyering is both lawyering at trial and lawyering after trial. And oftentimes those are not the same lawyers. You'll have lawyers that are trial lawyers that specialize and lawyers who are capital appellate lawyers, habeas lawyers. But they're very, very important.
Very clear, Professor. Thank you. The last 2 points I would like to talk about are role of racism and racial discrimination in the administration of capital punishment, first, and second, the methods of execution of capital punishment, legal injection, and how it is litigated, which are the main issues in this area.
Well, I suppose we should start with race.
Race.
Yeah, it's the first you mentioned, and it's an incredible sadness that the American death penalty is known for being racist. I mean, it's a sadness that it is racist and that's something, that we carry with us. So I was reading about, someone was writing about this, and they said something that I thought was really good. And she said, maybe it's not that the death penalty has a race problem. Maybe it's that America has a race problem, and it plays out in the death penalty, right? It's bigger than the death penalty, but it is especially terrible when it is affecting whether someone lives or dies at the hand of the state. And here I lay the blame at the feet of the Supreme Court, because the Supreme Court decided in the 80s, a case McCleskey versus Kemp, as you know, where a very famous and very good study was put before it. The Baldus study looked at over 2,000 murders in Georgia and looked at over 200 different variables. This was a statistical study. And even after accounting for 39 non-racial variables, so taking out everything you can. I mean, 39 is a big number to try to explain this. They took out everything. There was nothing left but race. Nothing left. And even then they found that someone who kills a white person is 4 times, a little more than 4 times more likely to get the death penalty than someone who kills a black person. And so one of the interesting things about that is that most people, when they think of racism and the death penalty, they think of discrimination against the defendant. And we have that too, make no mistake. But, the strongest correlation, sadly, is not just whose lives do we want to take, but whose lives do we deem worthy of protection? And it's white lives. It's white lives. So the defendants in that case brought the study to the Supreme Court. And I noticed in that case, perhaps you did too, that the court sort of fussed a little bit and then said, well, we'll take the study as is. And I always say they didn't want a better study. It wasn't going to work to say, well, this study isn't good enough, because they knew they would get a better study. And the General Accounting Office later did a study of studies and found that 82% showed the very same thing. This is not about the study. This is about the truth. And what the court said in response to that was that a defendant had to show intentional racial discrimination in his or her or their own case. So I have to show that the prosecutor is going after you because of your race or because of the race of the victim.
This is a burden that cannot...
When is a prosecutor, what does that even look like? No one's going to do that.
It's correct to say that courthouses are closed for equal protection claims.
That was a very nice way to put it. The courthouse doors are closed. They are closed, and the shutters are locked up, and there's no legal recourse against. There is no remedy. No.
It's pretty sad, I would say.
Very sad.
The state of the
Fine.
method of execution.
Okay.
That is the topic of your forthcoming book, The Secrets of the Killing State, right?
Yes.
Why did you decide to write?
Well, there is a story of faith in that that is separate, but I will say I've lost faith in this court to protect against torturous executions, to protect these people at all. And when I started out, I thought lethal injection was, I'm against executions, but I thought it was like putting down a pet, right? Like we put down cats and dogs every single day. And I thought it was like that. It's not like that. It is not like that at all. We don't use the same drugs. Everything we know about it is that we're torturing. The states are torturing these people. And the worst of them use a paralytic that is a muscle relaxant. So it relaxes the muscles in your face, and then it freezes them that way, and then it slowly suffocates you inside. So these are terrible deaths. There was a study in 2020 that showed 84% of these people are drowning in their own fluids. We are essentially waterboarding people to death. And Americans don't know. And the court knows this, the courts know this, the states know this. They're banking on the fact that people don't know. And I'd like to change that.
Letting them know.
I want everyone to know what we're doing. And, I have more faith in people than the courts right now. I think that it is outrageous what we're doing, and states are lying about it. That's a very strong claim to say that the state is lying.
We can't wait to read your book, really.
Thank you.
Thank you very much for for the talk with us, and we hope to have you again in the future at Extrema Ratio. It would be an honor, a pleasure, and thank you again. We are
the
really
pleasure's
grateful.
mine. This was a
Thank you,
real honor.
Professor.
Thank you
No,
so much
it
for
was
your
our
time.
honor. Thank you. Buona serata a tutti, arrivederci. Un saluto da Extrema Ratio per un diritto penale liberale, costituzionale, quindi minimo. Grazie, arrivederci.